Right. Good evening, everyone. And thank you for joining me on this talk on execution proceedings. We are going to talk about the objections in the execution proceedings under the Civil Procedure Code. I will not be touching upon the procedure which is enshrined in arbitration. But when you understand the procedure which is given under the Civil Procedure Code, you would see that the proceedings which are going on before other tribunals, for example, the Consumer Tribunal or the Motor Accident Claims Tribunal, etc., etc., all of that will be covered by the Code of Civil Procedure 1908. Now, CPC generally, I think, in the law school curriculum occupies a slightly weird space in the sense that it is heavy on procedure. So someone who's in the initial years of law school might not be so adept at understanding the procedure entirely. But at the same time, it also has a few basics in it. For example, the principle of res judicata. For example, what a decree is. For example, what is a stay of a suit, how to institute a suit, etc. These are the basics before which you cannot proceed with other acts and with your further studies in law school. So I think the course masters thought it best to keep it within the third year. That's perfectly all right. And for people who are here who are not well versed with CPC at all, I'll try and make it simple for you, because the area of execution, believe it or not, covers about 25 to 30% of the CPC. So the execution starts from section 2 of the Civil Procedure Code, from section 36 to section 72. So that's about 42 sections in that part. And there is Order 21, which carries about 106 rules. So you can very well imagine how elaborate and how exhaustive this entire procedure of execution has been made, only to make sure that the decree which is secured by a party is not defeated or is not prolonged. But as is what happens in anything that is so verbose, is that people and lawyers find ways and means to prolong it anyway, precisely because of the fact that this entire proceeding is so exhaustive. So that is where the issue of execution comes in. Now I'm going to divide this talk briefly on the issue of execution, which you will first understand as to what the procedure is. Second would be the modes of execution, as to if you get a client who has a decree in his favor, what and how should you advise him to then further get that enforced. And the last bit would be covering the objections bit, where, for example, a judgment debtor or a third person who is affected by the decree or the execution proceeding comes to you, how should you advise him and what objections should you file to probably prolong that procedure or to ultimately get relief for your client. Before we begin, I think it's very important to start off with what the difference is between a decree and an order under the code. Why I say so is because Order 21 carries the heading upon itself that the procedure, that the enforcement of decrees and orders would be covered under Order 21. It would be advisable if all of you have the Civil Procedure Code handy with you at this time, probably in text, or if not, readily available that way. If you can see, if you have any queries with regard to the sections and orders which keep on coming on the slides, you can check that online as well. It would be better if you have a textbook with you, because I think it would give you a fair idea of where each and every place, so it's easier for you to remember whenever you have your exams coming, or for legal practitioners whenever you want to refer to the Civil Procedure Code. So back to the difference between decrees and orders. Now, section 36 of the code categorically says that the provisions of the code which are relating to the execution of decree would also be deemed to apply to the execution of orders. And a decree is defined under section 2, subclause 2, as a formal expression of adjudication that is conclusive, that conclusively determines the rights of parties with regard to all the matters in the controversy in a suit. And what this means essentially is that a judgment is written and the decree follows the judgment. So the judge is going to frame the issues which are there on the basis of the cause of action which is arisen by one party, which is then defended by the other party. The issues are framed, the evidence is led qua each of the issues, and subsequently the decision is given in the form of a judgment. Now, the formal expression of this entire adjudication of the judgment, which would probably be 20, 30, 40, 60, 70 pages, whatever it is, forms the judgment, and the entire expression, then formal expression, comes as a part of the decree, which is a 1-pager or a 2-pager, to essentially state as to what the relief given is to any of the parties, or if the suit in its entirety has been dismissed, right? Now, decrees are of many types, which we would be following on the next slide. But before that, an order which is defined under section 214 is something which is slightly strange, because it says that it is any formal expression of a decision of a civil court which is not a decree. So anything that is not a decree is stated to be an order. What this essentially means is that any adjudication on any application during the pendency of the civil suit would come within the definition of an order. And there are times when you would want to get an order executed as well. An example could be an order of 39 rule 1 and 2 for injunction, which has not been carried out. So you may have to apply for execution of that order. Another example, as I said, is that if, for example, a motor accident claims tribunal gives its decision, that is termed to be an order. So then execution of that order for any claim that you want to seek in an accident claim would necessarily be followed under order 21. What typically happens is in a suit is that the first, and this is, I'm giving you this example because this would be, this would clarify your understanding of what a decree and what an order is. When a suit is generally filed, the defendant's first instinct is to file an application under Order 7, Rule 11 for rejection of plaint. He may have basis to proceed with the application under Order 7, Rule 11, or at the same time, he may just want to prolong the civil suit before he can get his act in order and he can probably gather his defense. So this becomes a pause moment for him, and the court has to necessarily adjudicate upon his application the moment it is presented. Rejection of plaint can be on various grounds which are mentioned under Order 7, Rule 11. What it means is that the suit will not carry on. The plaint will be rejected at the outset. Something similar generally in the criminal law, what happens is where the FIR is quashed at the outset. That is a procedure which is prescribed under section 482 of the CRPC. The civil suit will not proceed further only if the court finds that Order 7, Rule 11 is attracted to it. That could be whether the plaint does not disclose a cause of action, whether it is barred by principles of barred by law, which includes res judicata, whether it is deficient in court fee, and so on and so forth. Now, if the court comes to a conclusion that Order 7, Rule 11 application is to be accepted, yes, the plaint does not disclose a cause of action. In that scenario, the decision which is given would be treated as a decree. This is something which is called a deemed decree, because it is not technically a decree, but it has to be treated as a decree because this is the final adjudication on the suit, right? But in case the court does not find any ground to entertain this application under Order 7, Rule 11, then it would be treated as an order, and that order can further be challenged in the High Court under Article 227. Usually it's under Article 227, and it could be called civil revision, it could be called a writ petition, or whatever the rules and orders of the High Court are. But it is amenable to challenge, but it is not treated to be a decree because till then the suit is going to carry on, right? So this is probably the primary difference between a decree and an order. Otherwise, in terms of an execution proceeding, there doesn't seem to be any other difference. To understand what decrees, what types of decrees are, we have a few of those. And this is important to understand because a lot of times when a client comes to you, and he might come to you in a panic moment where probably a decree has gone against him. and he will pressurize you to file an appeal immediately, or or subsequently go or try and stop the execution, or try any mode so that the decree is not enforced against him. You must understand what this decree is and how it translates into the advice that you're going to give to your client, right? So one of the basic issues is the difference between preliminary decree and a final decree. A preliminary decree is formed by a courts when there is still something more which requires to be determined. So the rights of the parties have been determined, but subsequently some sort of a further inquiry is required to ultimately decide as to what the final decree would be. And there are certain suits where drawing up a preliminary decree is essential and mandatory. The example of which is, let's say, a suit for foreclosure, or a suit for redemption, or a suit for which is filed for administration. Now, foreclosure and redemption are suits which are relating to mortgage of property, and a foreclosure suit would be filed by a mortgager to say that I want this mortgage to end, and this is the money which I owe to the mortgagee I am paying herewith. Why a preliminary decree would be required to be drawn up is because the courts will determine the liability of a party towards the other, and then provide a mode for handing the property back to the original owner, which is the mortgager. And for that, probably the preliminary decree is enough. But when you want this to happen at the grassroots level, you would require the assistance of, let's say, a commissioner, which is appointed under Order 26, a local commissioner, or any other revenue official, a tehsildar or a patwari, who would subsequently get that property back in the hands of the mortgager. And the liability also which is there, the court might say, okay, this preliminary decree is drawn up within a period of 30 days, X has to pay Y a sum of ₹100. The decree will only be the final decree will only be drawn up once this mode, whatever has been prescribed, has been done away with by both the parties, right? Similarly, in a suit for partition, something like this happens, where a preliminary decree may be drawn up, where, let's say, there are three brothers, A, B, and C, and all of them have a share in the property. A says that I want my 1/3 share and I'm out of it. B and C are fighting over more of a share. So in this situation, the courts may drop a preliminary decree, decide the shares, but it may seem to be determined as to who will get the physical possession in which part. For example, the 1/3 share that A wants may come to the northwestern side of the property, right? Now, whether that northwestern side of the property is inhabitable or not is something that would be required to be seen again by the local commissioner. Once all of this is decided, the decree then subsequently culminates into a final decree. And this final decree is the one which is subsequently executable. The preliminary decree is not executable. So coming back to the first point which I was saying, if a client comes to you in a hurry to asking you to file an appeal immediately against a decree which has gone against him, it's necessary for you to see whether this is a preliminary decree or a final decree. Because if it is a preliminary decree, you would have to wait for the other party to apply to the court to get it into a final decree. Until and unless it culminates into a final decree, it would not be executed. There are times when the decree is partly preliminary and partly final also. Again, taking the example of partition which I took, if with regard to the share of A, which is 1/3 in nature, the court may say, okay, 1/3 is here and it is on the northwestern side. We know that this is habitable because A has been staying there for the past 50 years. But we need to see where B and C will fit in. So with regard to A's property, the decree would be final if it is termed so. And with regard to B and C, it would be preliminary. The court has two options. Excuse me. The court has two options here. Now, either it can drop two decrees, one final and one preliminary, or in the same decree say that this portion is final and the other portion is preliminary. Now, in the former case where there are two decrees, the final decree would be executable, the preliminary decree would not be executable. In case where the same decree is there and it is stated to be part preliminary and part final within that one decree, within that one frame, you will not be able to execute that decree until and unless the entire decree becomes final, right? So I hope there is no confusion with regard to what a preliminary decree is and what a final decree is. But always remember that the executable decree is the final decree. Other types of decrees which you would come across under the code are decrees which are passed ex parte, which you would probably know is passed when one of the parties is not available, has not caused an appearance, and the decree has been passed behind their back after giving them sufficient notice. For that, you would want to go and read Order 9 in its entirety to explain how an ex parte decree can be secured and how and what situations can the court proceed ex parte. The other decree which can be executable is a deemed decree. Again, if you remember the example which I gave you with regard to Order 7 Rule 11, where the application under Order 7 Rule 11 is accepted, it is termed to be a deemed decree. Now, technically, Order 7 Rule 11, where it is accepted, the suit has been dismissed, so there is nothing probably to be executed, but there might be situations where an execution may be, where one party may require an execution of that. But I'll give you another example. It could be, for example, restitution. There is a concept of restitution where if ultimately a party which is unsuccessful eventually becomes successful subsequently and the execution has taken place, then it may apply for restitution back to what the position was. So for example, if I have lost the suit at the first instance and the other party has filed an execution and my property has been auctioned away, it has been sold, I file an appeal on merits against the decree which I had lost. I file an appeal against that, and that in that appeal, the findings of the suit are overturned. In that situation, I am allowed to move an application for restitution to say that the sale which was affected is incorrect and I should be put back into the position as what it was before the suit was filed. Right? So that is another example of a deemed decree which is passed in an application for restitution, which is also executable. You should also look at this judgment called Indu Singh and another versus Prem Chaudhary and others. This is a Delhi High Court full bench. Just note out the citation. It gives in detail the entire concept of types of decrees and especially elaborate on the issue of preliminary decree and a final decree and all the situations which it encompasses. I won't have too much time to delve into it today. We are going to move into the issue of execution soon, but I just want you to know these basic areas of what types of decrees are, because it ultimately reflects on how you proceed in an execution application. Now, finally, when we come to executing a decree, you must know that the application which is filed for executing a decree is always filed in the court of first instance. So for those of you who are not aware of the hierarchy of courts, I'm just going to give you a brief hierarchy. The suits generally, if there is no original side with the supervisory high court, in that situation, the suits will necessarily be filed before the civil judge, junior division or a senior division. The appeal against that decree which is passed by the civil judge will go to the district judge. The additional district judge also sometimes takes over that responsibility. That is interchangeable depending on the rules of that particular court and obviously the vacancies which are there. But the ADJ and the district judge are both competent to hear appeals under section 96 of the Civil Procedure Code. The second appeal against that goes to the High Court under section 100, and you must make out a question of law before that appeal is admitted before the High Court, right? So, and then subsequently against the judgment which is given by the High Court, you can move to the Supreme Court under the SLP 136, which is then converted into a civil appeal, right? So this is the hierarchy of courts. Now here the courts of first instance in the sense of a suit would be the civil judge, junior division or the senior division. And more often than not, the district judge of that area would have given the power of execution also to them. So normally the execution is filed before the courts of first instance. So even if you state that the execution should go before the district judge, it will eventually go before the courts of first instance, which is where the suit was instituted, until and unless the court decides to transfer it to some other court. One situation like that could be if A, who is the judgment debtor, and we're going to be using these terms, the judgment debtor and the decree holder. One who has the decree, who's won the suit, will be the decree holder. One who's lost is the judgment debtor, right? So the judgment debtor moves all his assets from place A to place B. The suit was decreed in place A. The decree holder files an execution application in A. A decides that since the entire assets have now been shifted to B, I'm going to send this execution to the court situated at B, and B will now take charge. Sorry, courts at B will now take charge. So this is how the transfer takes place by an executing court, and then courts at B would have the responsibility to see to the execution to the satisfaction of the decree holder. Now, one exception to this entire idea of courts at first instance is under section 44A of the code. And section 44A is a unique provision because it allows you to get foreign decrees, judgments or orders executed by courts in India. Again, there could be numerous situations, and often not what we see is when the assets are situated in India and for some reason the execution is not possible in the courts where the decree was passed. A lot of times this happens in the Indian scenario is in custody battles between the husband and wife or in divorce proceedings, right? So section 44A, an application, if it is moved, then that application necessarily goes before the district court. Or if it is the High Court which is exercising the original civil jurisdiction with regard to the pecuniary jurisdiction. So for example, if it is 2 crores in the Delhi High Court, then if the execution is of a decree which is more than 2 crores, this would necessarily be filed before the High Court at Delhi. But if it is below that, it would go before the district court, right? So this is a slight distinction from where a normal execution would go. The other differences are that judgment or decree must be from a superior court of a reciprocating territory. This does not necessarily mean that the superior court is a higher court in terms of hierarchy. Superior court of a reciprocating territory is a gazette notification which is given by the government of India under section 44A to state that these are the courts which would be termed as superior court of this territory, which is a reciprocating territory under so and so treaty which we have executed within these two states. So this, if the court is a part of this, only then would an application under section 44A be maintainable. The reason for this is that India is not a part of the Convention on Recognition and Enforcement to the Foreign Judgment in Civil and Commercial Matters. This treaty we are not a part of, so we execute bilateral treaties with other states, and subsequently the government comes out with notifications to say that all these courts would form the superior courts of a reciprocating territory. And of course, you need to then file the certified copy of a decree, etc., etc. And the courts, which is the district court or the High Court, will then take cognizance of it. One other thing is section 13 of the code. Now, before I just go to section 13 of the code, I want you all to remember that a cardinal and a foundational principle for execution is that the executing court cannot travel beyond the decree. So it is not open to the executing court to then find reasons as to how and why the decree was procured or secured. It just has to execute the decree as it is. One diversion that we see in section 44 is section 13 of the Civil Procedure Code, which lists out certain things which need to be satisfied before this application for section 44A is allowed. And that is that the foreign judgment needs to be conclusive under that code. The examples are that it should be a conclusive conclusive adjudication on merits, number one. Number two, it should not be procured by fraud. Number three, it should not be against public policy. And there are about 4 or 5 other things which are there under section 13. But this is where the executing court can put its foot down and say that you are not following, or this judgment or this decree does not follow these possible scenarios which are given in section 13 of the code. So I am going to refuse the execution. But if it is a domestic decree, which is passed by the domestic courts, the executing court does not have it in them to say that we are not going to execute this decree. It has to necessarily execute this decree until and unless objections are filed, which we would obviously come to later, right? And one last point which I want to discuss, and this is the point of limitation. The only thing that you need to remember with regard to limitation when it comes to execution is that from the date of decree, the limitation for filing an execution is 12 years. So any execution application which is filed beyond a period of 12 years would be barred by a limitation. Courts can refuse to entertain such an application. With regard to the application made under section 44A for executing a foreign judgment, the Supreme Court has last month just ruled, because there was confusion as to whether the Limitation Act would apply with regard to 12 years or whether the Limitation Act of the foreign country would apply. The court has now clarified that the limitation will be determined by the law of the cause country, which is where the decree was passed. And if, for example, let's say country A, which has passed the decree, the law of limitation for execution there is 3 years, then from 3 years, the further limitation period for making an application for executing a decree would be when the right to apply accrues, right? So it would be 3 years, which is the right to apply from there, calculated to the current scenario, which is executing before the courts here. I would somehow disagree with this, because I think that it is not open to the courts to look into the laws of the other country, and the Civil Procedure Code does not mention anything like that. So limitation, to my mind, should be applicable only in terms of what it says with regard to the execution of a domestic decree, which is 12 years. The courts cannot go looking into the acts of the laws of the other countries to calculate the limitation. I think that is going to create a lot of confusion in the future. But anyway, this is what the Supreme Court has ruled recently, and this seems to be the law which is to be applied for some time. Now, when you have to apply for an execution, for all practical purposes, your application starts under Order 21 Rule 11.2. And the format which is specified in that particular sub-rule, then continues to Order 21 Rule 13, 14, and so on and so forth till 15, right? One unique feature is that if you secure a money decree, and a money decree is when B owes A, let's say ₹100, right? So if you secure a money decree under Order 21 Rule 11.1, an oral application can also be made at the time when the decree is being pronounced. So you can ask for the execution straight off. But usually this does not happen, because I think the courts think that it's better that a written application comes to them so that it can be numbered. It is just ease of convenience that a written application can be then taken and a show cause notice can be given to the other side. So the routine process takes place. So most executions, in fact, all executions generally take place under Order 21, Rule 11, and that format which is specified needs to be followed strictly. In case the court comes to the conclusion that there is some sort of a defect, it will give you some time to remediate. But if you do not remediate within that, then the execution can be dismissed. So one thing that you need to be very sure of is your format of filing the execution application. It should necessarily comply with whatever is given in the Civil Procedure Code, because otherwise you would be delaying the execution for your client, which is not a good thing, because that is probably the other lawyer's job, right? So the notice which is issued then goes to the judgment debtor to ask him as to why the decree should not be executed. Now, this is the first time after the notice is issued and the judgment debtor causes an appearance. This is the first time where objections can be raised by the judgment debtor. And those objections fall under Section 47 of the Code. Section 47 says that any issue arising out of the execution or with respect to the legal representatives of the parties would be necessarily decided by the executing court. So any objection which is given by the judgment debtor with regard to why this decree should not be executed falls within the parameters of Section 47. One example which I can give straight off is that if, let's say, A owed B rupees 500 before his death. Sorry, A gave I can just modify it a little. A gave B 500 rupees, and B files a suit. He procures a decree against A. A dies, and then B files an application under Section Order 11 Rule or Order 21 Rule 11 for execution. The legal representatives are also then made a party to this execution proceeding. What happens is that I find a will which is towards B, and I am C, who is the son. B is the legal representative. The will is not challenged, but I am also made a party. So I can move an objection under Section 47 to say that this is a will which goes to B, the entire estate goes to B. So B is liable to satisfy the decree, not me. So this probably offhandedly is an example which I just gave you with regard to how an objection under Section 47 can be made. After this preliminary hearing, whatever or deciding of the objections, if the court is satisfied that the decree has to be executed and the objections are dismissed, the process for execution is then given under Order 21 Rule 24. And if after that also the execution is not satisfied, then you come to Section 51 of the Act, which says that these are the measures for enforcement. And there are three main measures for enforcement of an execution. I hope we're clear till now, because this would start a new chapter, which is enforcement of the execution. The enforcement takes place primarily by three ways. One is attachment, the second is arrest, and the third is sale. Now, with respect to attachment, you could attach a movable and an immovable property, the salaries, allowances of private individuals, negotiable instruments, shares, decrees, etc., etc. Whatever it is that can secure the decree for the decree holder can be attached. But there are a list of other things which are given in Section 60, things which cannot be attached. So that's a huge list that you can go through in the Civil Procedure Code under Section 60, which are the things which cannot be attached. Now, once there is an attachment, the attachment generally, for example, if there is an attachment of salary or if there is an attachment of the bank account of the person, now the idea is that you stop the flow of income into that account, or you also stop the person who is the judgment debtor from paying out money to someone else. So that can be slightly suffocating for a person, and you can hope that he may cough out the sum which is due to the other person, right? With respect to arrest, that is the other thing. The courts may order arrest, and that is 3 months, for a period of 3 months, where the decree is for a payment of sum exceeding rupees 5,000. So usually it is 3 months, because mostly the sum is exceeding rupees 5,000 in this day and age. Or it is 6 weeks between 2,000 and 5,000. Anything below 2,000, the court does not have the power to arrest or detain a person. Another area where arrest cannot be made is if a woman is the judgment debtor in a money decree. So a lot of PILs have been filed against this to say that this is discriminatory, but they've all been set aside, and the vires of the section have been upheld in terms of Article 15.3 to say that the state can do whatever it feels best for the needs of women and children and the other social classes. So Section 56 very well remains a part of the code till date. But one thing that you need to understand is that the power to arrest does not follow attachment. So the court in certain situations, and we will discuss those situations, in certain suits has the power to proceed with arrest straight away without attachment also, right? Usually that does not happen, but you cannot question the court where the arrest has been proceeded with as the first mode of enforcing the execution. Once the person is released after the period of detention, which is 3 years, the court does not have the power to re-arrest him, but the debt still remains. So that debt will not be written off. The person may be out. Probably the decree has not been satisfied, but the execution will remain pending till the decree is satisfied, right? If in case you understand as a decree holder, you understand that the judgment debtor is slightly slippery. He's selling away all his assets. He does not want to satisfy the debt under the decree. You may apply under Order 21 Rule 11A detailing the grounds for such an arrest. Now this application necessarily has to go under this rule. Why I'm so hung up on these orders and rules is because any slip up by a party is what the other party can take advantage of. So for example, if the application for arrest is made under Order 21 Rule 11, which is the simple mode of seeking an execution, this could very well be your ground of defense if you are for the judgment debtor because you want to save him from the arrest. You can tell the court that this is an application which is defective. It cannot be filed under Order 21 Rule 11. It has to go under the format which is prescribed under Order 21 Rule 11A, and he has to detail the grounds for such arrest. Because the grounds have not been detailed, this application needs to be dismissed, right? So everywhere when I'm talking about these orders and rules, you need to understand that it is very imperative for the parties and for you as a counsel also to follow this procedure to the hilt. Because if you do not, the other side is going to immediately take advantage. They are going to find any way to delay the execution which you have filed, right? So be very, very careful with what provisions you're using whenever you're filing an application for execution. Anyway, coming back to the issue of arrest, of course, the arrest cannot be done without showing cause to the other side. So the notice will be sent, the other side will make an appearance, and you will have an opportunity to defend yourself, to say why the arrest should not be there, or give an alternative as to, okay, I have this property, I have this account, you can attach it, don't arrest me at this point of time, I am ready to pay this, give me some time, whatever the usual excuses that judgment debtors and lawyers make. After this satisfaction, if the court comes to the conclusion that attachment has to be done, then attachment would proceed in terms of further sections which I'm going to discuss. But if it is arrest, then it is Order 21 Rule 40 and the order of arrest is made. Now, if the order of arrest is made, the court has the option of releasing you, subject to furnishing of some security. So you could furnish some security and be released at that time. But it must necessarily be at a stage where some sort of an inquiry is pending, right? So if there is an inquiry which is pending with regard to the fact that you are not going to get away, or these are the assets that you have, we can really realize the debts from these many assets, then the court can, till the pendency of this inquiry, release you subject to furnishing of such security. But otherwise there is no provision for bail in the civil procedure code. That is under the CRPC, but you cannot apply for bail under the CRPC if the arrest has been made under these provisions by the civil judge. The option that you then have is to file an appeal before a higher court or a revision or whatever, right? So this order has to be challenged. The order of arrest has to be challenged, and you would most probably be taking the same grounds which you have taken before the court here as to why you should not be arrested, and as to how the procedure which was prescribed by the court is not in accordance with what is given in the Code of Civil Procedure, right? So the attachments which are there, one reason, as I said, for attachment could be to stifle the existence of the judgment debtor, to make him insecure with respect, not giving too much room to move around, and to make sure that he ultimately satisfies the decree. But the other area where attachment is essential is that the property is sold subsequently. If it is an immovable property or a movable property, it is subsequently sold, but attachment is a prerequisite for sale. And these modes of sale are given under Order 21, Rule 64 and 65, right? This is usually done through a public auction, and a proclamation is generally given to the judgment debtor and a decree holder, and then subsequently it is published in a daily newspaper. 15-day period is given to the judgment debtor to give his consent if it is immovable, 7 days for movable, and if such consent does not come within, after that the sale can take place. And this proclamation generally takes, if it is adjourned beyond a period of 30 days, this entire procedure will restart, right? This is where the problems of execution arise. So you can see that here a very elaborate process for sale is given, for attachment and sale. And subsequently, for some reason, if the sale is adjourned beyond a period of 30 days, the court has to then go back and publish it, give a notice to the judgment debtor, give a notice to the decree holder, get that publication in the newspaper. It is extremely cumbersome, right? And here also, if you see that the decree, if you think that the decree holder will have the first right to participate in the execution and bid for that property, that is incorrect. The decree holders or mortgagees would require an express permission of the court to participate in bids. Again, this is important because more often than not, the decree holder would be interested in getting the property, or the mortgagee definitely would be interested in getting the property because he's been holding a right on it for so long. But if he participates in the bid without permission, you can, as a judgment debtor, you have the right to get that sale set aside. So you can imagine here is a situation where this is a judgment debtor who has lost in all courts, has a decree against him. The decree holder is probably on his knees to get the decree secured. But still the execution can be frustrated by the judgment debtor if he finds a small issue like this, that the permission of the court was not taken by the decree holder or a mortgagee to participate in bids. So these are all the nitty-gritties that you need to be aware of in terms of procedure if you want to advise your client properly, right? So even if the court comes to the conclusion that this is a Benami sale and this sale has been made without permission, if I as A have given B the authority to participate on my behalf, court finds it, the judgment debtor finds it, that this is a Benami sale which is taking place, you can get the sale set aside immediately, right? The 25% of the deposit has to be made immediately, and subsequently the remaining amount has to be paid within 15 days. In case it is defaulted, then the property would be forfeited to the government, and then the issue of resale would be done again, and again the entire process would be notified, right? Now, there are two ways of which objections can be taken at this stage. The objections with regard to attachment are taken under Order 21, Rule 58, and under Order 21, Rule 97 and 99 is at the time of delivery of possession, right? So, for example, if the property has been attached and it appears that the attachment is causing some grievance to a third party, that third party can approach the court under Order 21, Rule 58, and the court is then going to decide whether to entertain this claim or not. If it decides to entertain this claim, issues will have to be framed, evidence would have to be led, and subsequently it would probably be treated as much as a suit would be under the proceedings of an execution. Now, this is usually where the execution gets delayed, right? I'll give you an example as to where these issues can come in. Now, let's look at this. X is Y's daughter-in-law to the deceased elder son, right? So X and Y share a relationship of a mother-in-law and a daughter-in-law. And Y's son Z is also there, and all three of them form a partnership firm with their operations running from a commercial establishment. X files a suit for dissolution of partnership and rendition of account. But the parties enter into a compromise decree, and it is agreed that X has to pay rupees 100 to Y and Z respectively, and in lieu the commercial establishment would be transferred to X, and this would be in her own right. The possession would have to be delivered within a period of 3 months, right? Now, in this situation, Y and Z, who continue to occupy the building for some time, do not transfer the property in the name of X, with definitely not possession within a period of 3 months. X then enters into an agreement to sell, to say that, right, on the basis of this decree, waive off my 100 rupees debt, I am going to sell you this property, my liability is waived off. In the agreement to sell, nothing to this extent is written, but it is an implicit understanding between the parties. Y then institutes a suit for specific performance because X has not fulfilled a liability, no sale deed has been delivered to Y. Y institutes a suit for specific performance, and during the pendency dies. Z steps into her shoes and continues the suit. X denies the agreement in its entirety, says that this is a forged and fabricated agreement, and then contests the suit. X finds a way to get the property back, and that is by filing an execution of the compromise decree. And the court attaches this property in execution. Now, Z can, at this point of time, raise objections under Order 21, Rule 58, even though he is a judgment debtor, to say that my suit for specific performance is pending. And if it appears to the court in that the agreement to sell was valid and X, in fact, had executed this agreement with the intention of selling the property to Y, then what would happen if you attach this property and sell it today? So, stay the execution proceedings till the pendency of such a suit. So these are examples where Order 21, Rule 58 comes in. The other examples are here, which I've listed. There can be number of examples, but something to just make you understand. For example, could be with regard to claims of debts. Now, if it appears that X had a debt towards Y, who is the judgment debtor, the court calls upon X to satisfy the debt so that it can be given to Z, who is the decree holder. X says that, in fact, although I owe him 100 rupees, but Y also owes me 500 rupees, and a separate suit is already going on. So X can file an objection under Order 21, Rule 58 to say that I am disputing the liability. The liability is much more towards me by Y. So you can't call upon me to satisfy this debt, right? If there is a subsequent purchaser, if an attachment has been made and the purchaser of the property, who is subsequent to the attachment through a private deal, realizes that the property was already attached, he can also come to the court and raise these objections. But once the court comes to the conclusion that such an objection has to be entertained, then it must definitely try it as a civil suit. Right? These objections can be made till the time of confirmation of sale. So even if it is advertised that the sale is going to take place, but the sale has not been confirmed, the parties are not precluded from filing an objection under Order 21, Rule 58. Right? Again, the adjudication of a claim under Order 21, Rule 58 is treated as a decree. So an appeal would lie under Section 96 of the code. This is another example of the deemed decree that we had spoken about earlier, right? So this is the procedure which you can see on the slides. I've already mentioned that evidence would have to be given by both parties and due opportunity of hearing would be given to accept or reject the claim. Now, if you are someone who is the decree holder and such an objection does come in, you are going to try your level best to tell the court that this should not go to the stage of evidence. This is a bogus claim which is come, right? And try and get, the burden is obviously on the one who is filing the objections, but try to get the court to you towards your side to say that this claim should be rejected at the outset, right? For the other side, it would be the complete opposite. They would probably want to take it to the stage of evidence so that the execution can be delayed as much as possible. The other problematic area, which probably would be the last area with regard to objections that we're going to discuss today, is Order 21, Rule 97 to 101. Here also, after attachment, after the sale, for example, if there is a subsequent purchaser, which is the purchaser from the sale, the court auction, he is resisted from taking possession of the property, assuming he is successful in the sale also now. And he physically goes to the area, realizes that there is someone who is occupying the premises. He can approach the court under Order 21, Rule 97 and complain of such act and seek the assistance in the delivery of such possession. The converse is also true. If there is a person who is occupying the premises and the delivery of which has been ordered by the court, he is unaware of this decree, he is unaware of the execution, he files an application under Order 21, Rule 99. Now, the language under Order 21, Rule 99 is any person occupying the premises, right? Any person who is found occupying the premise, that could also be a squatter. This is where the language, I think, needs more, an amendment should be there, or there should be some change in the language. It needs to be more elaborate as to who this person is going to be, whether he's going to be a tenant or not, because ultimately even a squatter on the property has the right to file an objection under Order 21, Rule 99. So more often than not, where a judgment debtor realizes that he's lost on all accounts and now even the sale has taken place, he may, at his instance, have someone sitting on the property so that an application could be moved by him as a third party objection under Order 21, Rule 99. And again, this application has to be tried as a civil suit by framing of issues, by leading of evidence. Now, the courts obviously are aware of the kind of tactics that people use. So until and unless there is some sort of evidence forthcoming at the first instance, courts generally would dismiss an application under Order 21, Rule 99 if it feels that this is an objection, frivolous objection, which has only been filed to delay the execution proceedings. But what it leads to is that that person has a remedy to appeal and to a second appeal. Because it is treated as a decree, as I said, deemed decree, this person can file an appeal before a higher court. And if it can satisfy that the court should have tried it as a suit but did not, till the pendency of this issue, he can obtain a stay on the execution. Till this court, the appellate court, decides whether this should be decided as a suit or not. And if the appellate court comes to the conclusion that it should be decided as a suit, then it will remand the case back and direct the executing court to then decide it as a suit. The reason for all of this is that prior to the amendment of 1976 to the code, the provision was to file a separate suit to make your claim with regard to the property at this stage. So a third party has the option of filing a separate, had the option of filing a separate suit until the pendency of this suit. the execution would be put on hold. So they felt that if the executing court itself could try it as a suit, this would be a much simpler and a much faster process, definitely faster than a separate suit. But I don't think there is any requirement of having such an elaborate procedure at this stage. And this is where most judgment debtors do try and frustrate the execution of a decree. The other areas of execution are this, where you can move an objection, where a garnishee, who is generally a guarantor, he disputes the liability, that is under 46C. Under Order 21 Rule 52, which is in a firm against a firm, if the execution takes place against a firm, the decree holder claims that the decree is to be executed against a third person, then special leave has to be sought. And I can just give you an example of an area where we won this case primarily on the issue of Order 21 Rule 50, subclause 2, because the execution was filed under a general execution was filed under Order 21 Rule 11 against a firm. The property of the partner was attached, but before the property could be attached, he had already transferred it in the name of his mother, who was not a partner. She was a third party. Admittedly, this happened during the pendency of the execution, so there was no equity in our favor. Clearly, he had done it to prolong the execution. And this would also be an issue of lis pendens under Section 52 of the Transfer of Property Act, that this is not a valid transfer. But that we took the objection that the application, if you wanted to proceed against the property which now stands in the mother's name, would necessarily have to go under Order 21 Rule 52, and this permission was not sought. The issue of whether it is lis pendens or not would have to be tried in a separate suit, where such a challenge has been made to the transfer. Since the transfer has not been challenged in this execution proceedings, and it cannot be challenged in this execution proceeding, the only remedy was for them to move an application under Order 21 Rule 52. So this is another example of probably you would like to call it rogue advocacy or whatever, but this is what you need to do if a judgment debtor comes to you and he's in dire need, he's facing an execution. These are the issues that you look at as to what procedure has been followed or not. Then, of course, there are the other areas of execution, which is setting aside of sale, something that we spoke about earlier, is where there is material irregularity or fraud in publishing or conducting it. So the procedure that we decided on the issue of sale with respect to giving the notice to the judgment debtor, etc., etc. If that procedure is not followed, the judgment debtor can move to the court and seek the setting aside of sale to say that this is completely against procedure. There is material irregularity in publishing or conducting the sale. So that is not correct. And of course, the issue of fraud is always there. And the last thing is that if the judgment debtor had no saleable interest, then the purchaser can get the sale set aside, because he comes to the understanding that the judgment debtor never held title and he had no interest in the same. So he could not eventually sell the property away to someone else. So these are all the issues where objections can be taken in an execution. This seems to be slightly complicated, but just to recap all of this, I'm going to simplify Order 21 for you. The execution which takes place is filed under Order 21 Rule 11. A general execution is filed under Order 21 Rule 11. The courts will have the options of either attaching the property or arresting the person, or attaching the property and selling the property, right? The objections can be taken under Section 47 at the first instance by the judgment debtor or the third party, against attachment under Order 21 Rule 58, and against possession under Order 21 Rule 97 and 98. The last thing that I want to say is that if you've followed this talk properly, you would have seen how difficult it is to get the execution done for a decree. And this is probably why mostly the civil suits take place for such a long time. They go on for so long that even after securing a decree, it is impossible for a person to get it executed. one last parting question, which some of you might have, is that if in a writ petition, for example, in the High Court, the decision is not followed, the person who is aggrieved generally goes to the court and files a contempt of court. That is, in a way, trying to get the judgment enforced. There is a procedure for execution also in the high courts, but usually people file contempt of court to get the judgment executed. Why then in a civil suit should you not file a contempt to make this entire process easier? The reason for this is that a civil suit generally follows on a process of admission and denial. This is an area which is going to be deciding the rights and liabilities of private parties. A writ petition generally is filed against a government action, and that government action, more or less, whatever the order impugned or the notification impugned is going to be admitted by the government, because it generally, of course, it's going to be passed by the government, so it will be admitted by the government. In a civil suit, for example, if there is a title dispute, I can show one document for the title, the other person might have a document towards the same property. So it is an issue of competing sale deeds. In that situation, what happens? Evidence has to be led, admission and denial of documents has to be done. So which is why it is extremely, and of course, if there is a collusive decree which has been procured by some people, A and B get together and get a decree to defeat the interest of C, C is not aware of it at all, then C should have the option of filing objections at the time of execution. But saying all of that, I don't think we need such an elaborate procedure for execution. The entire procedure can be trimmed down. The requirement of treating some of the objections as a suit should be done away with. And probably, hopefully in the future, if we see some positive amendments, the area of execution would be much easier to understand. So that would be it, everyone. I hope there are some questions to what I said. Whatever questions you have, just put them on the screen and I'll be happy to answer them. Rupin, I can't hear you.
There is one question on the chat window.
Yeah. Just a second. Could you just read it out?
Okay, there's a question by Shiv. He's asking, why is a consent of JD required before attachment?
This is okay. Why is it exactly right? So the consent of the judgment debtor is technically, I would say, not required. But the issue is that since he is the title holder of the property, it would be just that he gives it in writing that yes, I was unable to secure this decree because of X reasons or Y reasons, because I did not have, and because of this, you can take away my property. So I am selling this property because I could not satisfy this debt. The consent would most likely be towards that.
That was the only, there's one more question which is in the Q&A window.
How is the attachment? Yeah. How is the attachment of the bank account to be dealt with if the account holder changes the source of funds? Right. So this is a good question, but you would note that if the account, so generally what happens is, let's say it is a company which is in default. The company would be having various accounts in different areas, right? One of the accounts, if nothing else, would be working. Even if the company gives a bogus account to you and you realize that it does not have money, the option that the court has, or you as a lawyer for the decree holder, is to immediately move an application for arrest, right? So if you see that there is a change of source of funds, or there is some sort of a mischief which is being made by the judgment debtor, immediately move an application for arrest of the highest functionary of the company, which could be the MD or the CEO or whoever it is. Or if it is in the nature of a private party and a sole individual, then you realize, then you make sure that his salary account is attached, right? If he's a private individual, you make sure that his salary account is attached so that the regular salary that he gets comes eventually to the court, right? So these are the areas where you can get your decree enforced in case you see some sort of a mischief which is being made by the judgment debtor. We have some other questions as well. One is, what does a decree holder do if insolvency proceedings commence against the JD after obtaining the decree? That's again a very, very good question. In fact, I wanted to talk about this. Usually, if it appears to the court that the person has become insolvent, there are two ways. The party, which is the judgment debtor, would usually apply to the court to say that now I have become insolvent and a receiver should be appointed. If a receiver is appointed, then the receiver will make note of all the assets of the insolvent person and see as to from where the debt can be realized. That is one. The other is that the decree holder makes an application that the person has become insolvent, so appoint a receiver. There is a third situation where the insolvency proceedings commence. Now, if the insolvency proceedings commence, in that situation, that would be left to the resolution professional under the insolvency bankruptcy code. And the resolution professional will then take over all of the responsibilities with respect to the satisfaction of the decree as well. In the old Act, Companies Act, it was the official liquidator. Now it is the resolution professional. So if the party turns insolvent, there are the receivers or the resolution professionals who take over the entire proceeding and try and satisfy the debt towards the decree holder. I hope that answers your question. We have another question. Could you please clarify that is it solely the discretion of the judge to warrant an arrest or attachment? Can the decree holder ask for either attachment or arrest in the first instance? So it is the discretion of the judge to proceed with the warrant of arrest at the first instance. And in situations where it can, is, let's say, a decree which is for specific performance, for for attachment of a movable property or an immovable property, not for restitution of conjugal rights. So in these 2-3 situations where the code says that attachment or arrest or both, in that situation, it is the discretion of the court to go ahead with the arrest. Usually that does not happen, but as I said, it is the discretion of the court. The other part of your question is, can the decree holder ask for either attachment or arrest? An application, as I said, under Order 21 Rule 11A would have to be moved specifically for arrest, but you would have to detail the grounds for why you are seeking the arrest of the person and why you are not interested in the attachment of the property, right? So that those grounds would have to be given, and the court can then look into it and order accordingly. This last question by Suresh. What is the way forward if someone not aware of the assets, property, if someone is not aware of the assets or property held by the defaulter? So usually what happens is that if you are, let's say you are not aware of the asset, if it's a money decree, for example, and you are not aware of the assets of the judgment debtor, you can be safe to know that the judgment debtor is going to cause an appearance in court. The judgment debtor is coming to court. If he is not causing an appearance, the court is going to order warrants of arrest. If he causes an appearance, the court can threaten him with arrest to furnish a list of immovable and movable properties, which would then force the judgment debtor to come forward and give a list of the immovable properties and movable properties. The court can also impose costs, but usually the court threatens the judgment debtor with arrest. So ultimate powers of with the court remain with respect to arrest to make sure that the decree is satisfied. And usually after arrest or around the area where the court orders an arrest, people do not default on a decree. It is very, it's easier said than done, but it's extremely painful to go to prison for something like this. I hope that answers all your questions. If you have any more questions, you can email me. with regard to execution. If there's something with regard to the talk that you didn't understand, and if there are some more examples that you would want, you can again email me, and probably Rupin can share my phone number as well. You can talk to me online as well, right? So I hope that was a fruitful session, and I thank Aditya and Rupin for taking this initiative. This is a great, brilliant initiative, I think, during the lockdown, and it's enriching all of us. I've been glad to hear the other webinars as well. Extremely, extremely informative. Thank you, Rupin. Thank you, Aditya.
Thank you, Abhilaksh. And Abhilaksh can drop in or just speak out his email ID so that people, if want, they can email him.
Sorry, my email ID is abhilakshgrover@gmail.com. abhilakshgrover@gmail.com.
Thank you, guys. Thank you for attending. Thank you, Abhilaksh.
Thank you so much. Thank you.